Good morning, everyone. I'm trying to let everybody in from the lobby, and then we'll go ahead and get started. I want to first thank Michael Merino for joining us again. He did a class for us just a few months ago, and now with the changes to our condominium writers, I've asked him to come back, and he is here. All right, guys, I'm going to have to mute.
It took me forever.
Guys, I'm going to have to mute everybody. Put yourselves on mute, please. So let me introduce Michael. Michael Merino is a Florida Bar Board certified attorney. He has been practicing law in the state of Florida since 1995, and his firm handles a variety of legal matters, including, of course, real estate transactions and litigation, foreclosure defense litigation, condominium and homeowners association law, consumer law, and business transactions and litigation. He's also a frequent lecturer on topics ranging from real estate, land development, estate planning, non-resident tax and estate planning, asset protection, digital assets, and one of my favorites, cryptocurrency. Mr. Merino has offices in Davie and in Palm Beach Gardens, and he's also available via video conference to clients all over the world. He's a member of the Florida Bar, Real Property, Probate, and Trust section. He's also a member of the Federal Bar for the Southern District and Middle District of Florida. And with that, I'm going to go ahead and turn it over to Michael for our class today.
All right. Good morning, everyone. It's a little weird because I can't see myself and I can't see anybody. So I definitely feel like I'm sitting here talking to myself. But welcome, everybody. This is Florida Condo Transactions post Surfside. A lot of you, I would imagine, came to the first one, and now you're back for the updates. When I was asked to do these updates, there really is, it's the rider, which is just a few paragraphs. And then there's a lot of other stuff that's come out from this law that we're going to discuss, including some of the glitches in the law. And Melanie, I keep getting a kind of a beep beep noise. I don't know what that is.
That are folks joining us late. I'm just
okay. Those are I see. So every time I get a beep, it's another person coming in?
That is correct.
All right. Well, welcome. Good. That's good to know. So in any event, my name is Michael Merino, and as Melanie gave in the introduction stated, I'm a Florida Bar Board certified attorney. There's my email and my phone number if anybody wants to give me a call or send me an email with a question. I'd be happy to answer it. So let's go ahead and go through. As with a lot of my presentations, I include a lot of photos. None of them really have anything to do with the materials. I know some presenters like to, have a two-hand shaking when they're talking about contracts or something, but mine are just random photos just for your viewing pleasure. So let's go ahead and get the ball rolling. And the first thing, like most lawyers, is a disclaimer. This is for educational purposes only. This is not legal advice. If you need legal advice, let me know what the specific facts are and we can talk about it. And we'll go from there. And if you want to take photos of the slides, you can. And if you want a copy of the presentation, feel free to ask. I will send it to you if you'd like. A little bit about us. I know Melanie gave you a little bit of an intro, but yes, I've been practicing since 1995. I'm board certified by the Florida Bar, member of the Florida Real Property, Probate, and Trust section. I'm also fluent in Spanish, do a lot of Latin American work, and again, a member of the Southern and Middle Districts. A little bit about what we do. We do, of course, real estate law, purchases and sale of businesses, stock sales, dispute resolution, asset protection and entity formation, estate planning, business law, commercial lease prep, condo and HOA law, which we're going to talk about today, and non-resident business tax and estate planning as well. We also help people with crowdfunding, syndication type projects, including tokenization of real world assets on the blockchain, including some digital assets law as well. Let's talk about what we're going to talk about, give you a little bit of a roadmap. We are going to talk about first I'm going to give you some hot topics and some proposed legislation, some of which is directly related to the topic, some not. I thought that it would be a good idea to show you some of the things that are happening right now and that could affect your practice. We're going to do a review of the updated condo rider. We're going to talk about Senate Bill 4D, also known as the Surfside condo law. We're going to discuss some of the glitches in the law and some of the issues that that are arising now that it's out and now that everybody's had a chance to sort of read through it. We're going to talk about some disclosure issues, a little discussion about due diligence, condo terminations, and some investment and listing opportunities as well. So let's go right into hot topics. So, you know, um, there's a lot of things that are happening right now in the legislature having to do with real estate. We're going to talk about those. I also wanted to talk about some I like to share articles that I've seen recently that again that sort of affect our practice and important things that I think that you should be aware of. And so the first is consumer optimism. Floridians are feeling much more optimistic in February. It went up almost 2 points in February, consumer sentiment, and consumer fears of a recession is declining. Of course, this was in February. Maybe in March, people are feeling different. That remains to be seen. Also, failure to disclose. I just wanted to reveal here that what's something I read, which is that the top claim against realtors right now is failure to disclose. Not revealing known defects to a buyer can put you in legal hot water. So some suggestions are don't complete the seller's disclosure form for your seller. Encourage them to reveal all of the defects and share them with the buyer. Carefully review the seller's disclosure to ensure that it's been properly completed. And if a seller refuses to disclose a material defect that you're aware of, you should probably disclose it to the buyer because there is a case I'll call Rayner versus Wise in the 4th District that essentially says that a broker is liable for the failure to disclose by their seller. So be careful there. Foreign buyers are back. Good news. They're returning to the housing market. And the pandemic, of course, reduced a lot of these foreign buyers. But it'd probably be a good time to ramp up your foreign national marketing, particularly in places like Brazil and Peru and Colombia, where they're experiencing some political change there. Condo insurance increases, very likely to increase significantly. One condo complex in Miami had a 300% increase, and their policy now costs 4.5 million. So in the course of doing your due diligence for condos, that might be a good question to ask, is whether or not they've received their renewal quote for their insurance, because of course that could significantly increase the assessments. And this is, of course, a potential nightmare scenario, sort of a perfect storm, because of the requirements for Senate Bill 4D, the Surfside law, coupled with this insurance issue. It could be catastrophic for the condo market. Home price increases. In Florida, over the last 5 years, we had a 73.5% increase in home prices. And you would think that we were in the top 3 maybe, but we weren't. Florida wasn't even first on the list. Idaho was first, with a 91.9% increase in home prices, believe it or not. And then Florida inbound migration. We have New Yorkers are the number one source. New York is the number one source of people moving to Florida. California, Illinois, New Jersey were also top sources, but New York seems to be where everybody is coming from to move to Florida. And Florida was the fastest growing state for the first time since 1957. Commercial real estate concerns. They're getting pummeled. Brokerages are preparing for very rough times and doing cost-cutting measures. So stay tuned to see what happens in the commercial market. All right, new laws. Let's talk about some of the new laws. As some of you have heard recently, we had a remote online notarization law that was passed in the House, which is going to authorize online notarizations nationwide, and it'll probably give us some national standards, national minimum consumer protections, fraud prevention standards. Now it's something that's very new. So one of the things I'm very interested in is how they're going to treat foreign nationals. Currently, if you are a Florida broker who wants to get a foreign national to execute via remote online notary, you have to go through Virginia to do it because they're one of the only states that allow for remote online notarization of foreigners. So I don't know whether this new federal law on the federal level, how they're going to treat foreigners, but something that we're following closely. Private property rights. You can now cut your trees down if you want to on your own property. The law prohibits local governments from requiring permits for the removal of certain trees, and it strengthens the owner's right to prune, trim, and remove trees as well. And of course, this has been a big topic, which is why they passed a law to strengthen those rights. Landlord tenant. Here's another important one. If you have a tenant on a month-to-month tenancy, statewide, it was always 15 days. You had to give 15 days notice on a month-to-month tenancy. But now you're required to give 24 hours. I'm sorry, I'm talking about access, not the termination rights. That I'm going to get to in a minute. So if you want to access the dwelling unit, it used to be that you had to give 12 hours notice. Now you have to give 24 hours notice. This has to do with a law that passed called the Myers Law, which was named after an Orlando college student who was murdered at her apartment complex. So now this law requires new, stronger tenant safety measures, requires background checks for employees of apartment complexes, and requires that there be key logs to track who took out the keys and when they were checked out for certain apartments. Another new law that came into effect is a new code enforcement law. It's been referred to as the Snitches Get Stitches law. And the reason for that is because the law requires that all code enforcement reports include a complaint, in the complaint, the name, address, and phone number of the person filing the complaint. The new law prohibits code enforcement inspectors from initiating investigations of potential violations if the complaint is anonymous. So what the law does is it prohibits anonymous complaints. And of course, critics argue that it's going to cause a chilling effect and prevent people from reporting things they otherwise might not report. And one exception, of course, is that violations that present an imminent threat to public health, safety, or welfare are going to be investigated regardless of whether the complaint is anonymous or not. The purpose, of course, is to save money and lessen nuisance complaints. So be careful if you're going to snitch on your neighbor, because your name will become public record. And again, that is a new law, not a proposed law. The other one I wanted to talk about briefly is local ordinances. And this is a very hot topic. I thought it was a good idea to talk about it today because a lot of people are falling into these traps. And so basically there's this preemption rule, the supremacy clause. And this is the age-old problem of state versus federal. Who decides? Who decides who decides, and who decides who decides who decides, right? So you have the conflict between the federal government and the state government, and the federal supremacy clause says that the federal law controls. You also have the same type of battle going on in states, and particularly in Florida, where Tallahassee wants to control everything that happens in the counties and the cities, but the state want to control their own destiny. So there's been many new ordinances that have been implemented throughout the state that affect housing. And so now what we're faced with is we have a patchwork of local laws that are different than what we see on the state level. So for example, there's vacation rental laws that are being implemented in places like Hillsborough County. There's new tenant termination and rent increase notice that are in Palm Beach County and Miami-Dade. So for example, if you're on a month-to-month tenancy in Miami-Dade or in Palm Beach County, you have to, and you want to terminate that tenancy as a landlord, you now have to give 60 days notice, not 15 days, as is required under state law. So if you're in Martin County and you have a month-to-month tenancy, it's 15 days, but if you're in Palm Beach or Miami-Dade, it's 60 days. So again, as you can see, this causes a lot of confusion. In Miami-Dade County and Palm Beach, if you want to raise somebody's rent more than 5%, you're required to give a written notice of 60 days. Okay, so again, be careful, be aware of these local ordinances. In addition, there's new discriminatory classifications in Miami-Dade County and Broward that don't exist in most other places of the state. So for example, you are not allowed to discriminate in Broward or Miami-Dade County for source of income, where somebody gets their income from. You can't deny them housing because of source of income. You can't deny somebody housing because of political affiliation, gender expression, veteran status, stalking, domestic violence. So what these counties have done is they've taken the Federal Fair Housing Act, which has your basic protections, race, national origin, etc., and they've expanded the discriminatory classifications. So be aware of those, be careful. There's a rent control statute in Kissimmee, I believe, Orange County, that they're trying to implement. Again, only applies to Orange County. There's, of course, the reoccupancy certificates that a lot of us have seen in some municipalities. Miami Gardens has one, Hialeah has one. That is a local ordinance that is only applicable to that city. So again, as you can see, there's a lot of patchwork ordinances. So there is a proposed law now, Senate Bill 170, that requires local governments to show the impact of a local law on business and suspend the enforcement of that law while it's being challenged in court. There's also a vacation rental statute, which is a bill that's going to try to centralize vacation rental laws throughout the state and take the power away from the local governments. And of course, that battle has been brewing for a while. The Florida Association of Realtors supports the creation of this statewide uniform system, again, because it creates certainty and creates uniformity throughout the state. It also gives local government authority to pass laws which apply to all residential properties, not just vacation rentals. There's also a new realtor license plate. This is House Bill 675, and Senate Bill 1254 proposes the creation of a specialty realtor license plate. Again, this is proposed legislation, hasn't happened yet, but they're expected to pass. The license plate would go, the fees paid for the license plate would go to support Florida homeownership programs. So you can add that realtor license plate to the new specialty plates that we have here in Florida. The business rent tax is expected to drop to 2% in 2024. And lastly, hurricane protection for condo associations, another piece of proposed legislation that, if passed, it amends the Condo Act to require the declaration of condominium to designate specific entity responsible for installation, maintenance, repair, and replacement of hurricane protections. It also authorizes the board to install or require owners to install storm protection, and it prohibits boards from refusing to approve certain hurricane protection as well. Another one, land development. This law would require anyone who challenges this proposed development of land to pay attorney's fees if they're unsuccessful. Previously, if you were a neighborhood, for example, where a Walmart was going up next door and you wanted to challenge that, the neighbors wanted to get together to challenge that Walmart development, if you lost, you didn't have to pay attorney's fees. Now, this law would make them pay attorney's fees. So it puts some teeth in it in terms of challenges. And again, that's something that's been hotly debated. There's also one other one I wanted to mention: affordable housing legislation. There's a whole bunch of affordable housing legislation that's going to provide incentives to developers to develop workforce housing. Affordable housing, as everyone knows, it is a big, big problem here in Florida. So stay tuned for that. All right, let's get into condo law. As we talked about in the last webinar, this Surfside tragedy has really changed everything. It's changed the way that we view old condos. It's changed the way that Fannie Mae and Freddie Mac purchase loans. It's changed the way that insurance companies evaluate condo buildings, especially ones that are near the ocean. And so there's been increased scrutiny all around by all of these different entities to determine the structural integrity of a building, and to make sure that their lenders and insurers aren't getting into something that they are going to pay dearly for. So, and by the way, there's a few slides here you might recognize, because I figured some people that weren't in the last class are coming to this one. So there's a couple duplicates here, and this is one of them, which is just wanted to get on the same page of what a condominium is and what it is not. And according to Florida statute, chapter 718, a condo means a form of ownership of real property that's created by law, which is comprised entirely of units that may be owned by one or more persons, and where there is a pertinent to each unit an undivided share in the common elements. Okay, that is right out of the statute. And when a condo is created, when the declaration of condominium is recorded in the public records, then it becomes a condo. And remember that the portion of the condo property that's not included in the units is called common elements, according to the Florida statute. Limited common elements are the ones that are reserved for the use of a certain unit. Think balconies. So if you have a balcony that you have the exclusive use of, you don't own the balcony, you just have the use of it. It's considered a limited common element, and it's allowed for the exclusive use of that unit owner. And that's some of some definitions there that I wanted to address. The Florida condo market, we have contains about 1.5 million condo units, and out of these units, 912,000, almost a million, are older than 30 years. So again, this new law that was implemented requires buildings older than 30 years old, and in some cases 25 years, to get all these new inspections and structural reserve reports, etc. So a lot of them are going to be affected. 37% of those condo units are in Broward and Miami-Dade County, and they're mostly older buildings. 75% of the condos were built before 1990, so the vast majority of these condos are going to be subject to this new law. One thing I wanted to point out is, how do you tell, or how do you get condo docs? Like if you're taking a listing or you're filling out a contract and you get to the condo writer and you get to that part in the condo writer that says, is there a right of first refusal? Well, I'm here to tell you that nobody knows. Nobody seems to know. Listing agents don't know. Buying agents don't know. Nobody really knows. The only place that you can figure this out is by looking at the condo docs. So, how do you find condo docs in public records? Well, first thing you want to do is go to the deed. And if you, in any county in Florida, you just need to go to Google County and Property Appraiser's office, and you will get the property appraiser. Once you get to the property appraiser's office, there is usually going to be a link called sales history. And in the sales history, it'll give you the list of the last deeds. Look at the last deed of record, click the little link, and it'll take you to the deed. Once you get to the deed, you're going to see the legal description, which will tell you whether it's a condo or not. Okay, so how do you tell? Well, this is what the giveaway is that it says declaration of condominium. If it says anything other than that, it is not a condo. It is not a condo if it doesn't say declaration of condominium. So look at what it says. It says as recorded in official records book 29821 at page 1290. So what are you going to do then? Well, you're going to go to the county recorder's office. So if you're in Martin County, you would type in Martin County recorder's office. That's going to take you to the county recorder where everything is recorded: mortgages, declarations, amendments, things of that nature, deeds. So if you type in, there's usually a little box that says OR book and page number. You type in these numbers, and boom, you're going to get a copy of the declaration of condominium. Some county recorders have links to all the amendments as well. But the important point is that if you need to figure out, does the condo have restrictions? What is the process for right of first refusal? What is the process for approval, etc.? You will find it in this document. And so it's important, I think, for all of you to know how to find the declaration of condominium and the amendments. That's how you find it. All right. Let's now go talk about the condominium rider. And the condominium rider in the new version of it, the first 2 pages haven't really changed. It's really just the last page that has changed. And one thing I ask is this: does anybody know who is supposed to initiate the condominium approval process? Anybody know that? Usually in a classroom, raise their hand.
Yeah, and if you have the answer, take yourself off of mute for a minute and shout it out. I do know the answer, but I'm not going to say it.
The seller.
That's exactly right. And the reason for that is that thank you very much. You guys, you get a free 3-day vacation on Carnival Cruise for that. No, just kidding. Now on the third line of this, it says on paragraph 1, seller shall initiate the approval process and buyer shall apply for such approval. So both parties have to take action, are required to take action. And if they don't, it's probably going to be a breach of contract. And I've used this as an attorney when I've had a buyer wanting to get out of a deal, and maybe we've already gotten our condo docs. One question I will ask is on what date did the seller initiate the process? And if the answer is no, then I'm going to jump up and down and say they breached the contract. So there's a lot of important stuff on this page. And if you definitely want to check that first box whether approval is or is not required. You want to make sure that you fill in the blank, or if you want to leave the 5 days before closing, that's fine. Again, depending on whether you have the buyer or the seller will dictate how you fill in those blanks. It's also important to note that second paragraph that talks about the right of first refusal. And there's also some affirmative obligations in paragraph 2C that requires the parties to use diligent effort to submit whatever's required by the association to initiate and finalize that right of first refusal process. So keep that in mind. All right, so let's talk about the second page here. And by the way, if anybody does have any questions, you want to unmute yourself, shout it out, or if I don't know if you're monitoring the chat, Melanie, but if you want to put it in the chat, you can also ask questions as we go.
Yes, basically, we have the Q&A box available, and you can also raise your hand, or when he asks you a question, again, feel free to just unmute and shout it out.
There you go. All right, so this is page 2, and this page 2 has a lot of different information. And at the top of the page there, you can see that the any fees that are imposed against the unit as of the closing date or any kind of charges or assessments, of course, are charged to the buyer. And then it goes into this paragraph 3C1, which I think is very important. This paragraph 3C1 says that this is a seller representation. And throughout the FAR bar contract, there are many seller representations. This is one of them. And what this says is that the seller represents that they are not aware of any special assessments that are levied or that have been an item on the agenda or reported in the minutes within the last 12 months. And if you notice in the parentheses, in the third line, it says pending. And so they define what they just said as pending. So anything that has been levied by the association or that has been an item on the agenda or discussed in the minutes is a pending assessment. Why is that important? Well, it's important because it says that if there's any pending assessments that are not disclosed, that it's the responsibility of the seller. So I think the point is that you as a listing agent and as a seller, you want to be aware of what is going on with your building and what's been discussed over the last 12 months. Otherwise, you can be liable. 3C2 says if there's a levied or pending special assessment, if that exists as of the effective date and they've been disclosed, then it can be either buyer or seller. So the point here is that you're better off disclosing. If the seller discloses a special assessment, then in paragraph 3C2, it can be negotiated. You can check that buyer pays it or seller pays it. But if it's not disclosed, the seller's going to have to pay it. So you don't want to have that surprise later on down the line. 3C3, it says that if it's pending or if there's a pending or levied special assessment that exists and it's not been disclosed, the seller has to pay in full at time of closing. Okay, that's 3C3. So 3C1 is a representation. It defines what pending is. 3C2 says that if there is a pending assessment and it's been disclosed, it can be negotiated. And 3C3 says if it's not been disclosed, it belongs to the seller. So again, very important stuff because you know how you shift these liabilities is going to depend on whether or not it exists and whether it's been disclosed. And again, this is why I think it's important as a buyer to contractually require the delivery of meeting minutes and the agendas for the last 12 months, because it's the only way you can get a pulse on what's happening in the association. You know, and I had one just like this. A client of mine got a letter. It was new construction. They got a letter from some big firm in Miami saying that they were going to sue them because they had failed to disclose all these construction defects and there was litigation ongoing. And so I asked them to send me everything that they sent the buyer, and lo and behold, they sent the buyer 12 months worth of minutes. And it was part of the contract. So I read through the minutes, and lo and behold, in the minutes, they talk about litigation. They talk about construction defects. They talk about everything that this attorney was alleging we didn't do. So it was a pleasure responding to this attorney to be able to say, guess what, buddy? You might want to talk to the attorney that represent them at the closing and make your insurance demand with them instead of with us, because it was properly disclosed. All right, note that levied also means that the assessment was levied on the date when the special assessment was approved per Florida law and the condo docs. Note the non-developer disclosure in paragraph 5. This says that the contract is voidable by the buyer from the date that begins 3 days after they receive a complete set of documents. And this is really important too, because now the condominium documents have expanded. Now it includes a milestone inspection report and a structural integrity reserve study, which we're going to review in some detail here shortly. So the important thing here is, I think if you're a listing agent, get a complete set of the condo docs, get the financials, get every piece of information that you can get that is listed here in paragraph 5. It says articles, declaration, most recent year-end financial statement, bylaws, and rules. Get it as early as possible. When you go into contract, have them deliver it and have them sign a receipt that they've received it. Okay, very important. Also, note in paragraph 3D talks about litigation. Note that the seller is required to represent that they're not aware of any pending or anticipated litigation that affects the property or the common elements. So again, if the seller's aware of it, make sure it's listed. You're always better off disclosing than not disclosing. Okay. The last one I wanted to mention on here is the sprinkler system retrofit. And I'm not going to go into too much detail about this, but I'm just going to mention this. The Florida Fire Prevention Code requires that all high-rise condominiums that are buildings that are about 75 feet in height or higher, about 6 stories, have to be retrofitted for sprinkler systems and engineered life safety systems by no later than January 1, 2025. This is a law that's been on the books for probably a couple decades, but they've continually kicked the can down the road and extended the deadline within which to comply. The reason being is that these were very, very expensive fixes. These types of retrofits cost millions of dollars. So to give associations time to prepare for this, they've kind of kept extending the deadline. Now with the Surfside condo bill and all of the requirements that that imposes, it's likely that this law will be once again extended. But note that paragraph 4 of this addendum says that the seller is essentially required to furnish the buyer the written notice that whether the association has decided to do the retrofitting or whether they've decided to forego the retrofitting. So probably another document you want to ask about. And if it's 6 stories or higher, you want to ask, what have you done about the sprinkler retrofitting? Most are probably going to say nothing. All right. So lastly is the new language. Okay. So the new language. So it used to be that it just said governance form in paragraph 10. The governance form is a form where the buyer is entitled to receive from the seller a copy of the condominium governance form, which is a format, a sheet that's provided by the Division of condominiums, which summarizes how an association is governed. In other words, we have a board and we have meetings and there's budgets, and it kind of explains the condominium form of ownership and condominium form of living and condominium form of governance. Okay, so that is how now they've scratched it out in red, but it is part of now paragraph 10, which is titled governance form, milestone inspection report, and structural integrity reserve study. So those are new terms that we're all going to have to get used to. And again, we're going to go into some detail of what they mean and what they don't mean. And then you have, that's the governance form. Then you have the milestone inspection report. What is that? Well, first of all, the seller isn't required to deliver the actual report, and the buyer is not entitled to the actual report, but they are entitled, according to this paragraph 10B, to a summary of the report. So keep that in mind. A lot of people want to just deliver a report, and it's very similar to the loan approval in paragraph 8. I get a lot of realtors that say, "Well, I delivered the loan approval to the listing agent already," and I always say, "Well, why? You're not required to deliver a loan approval. You're required to deliver notice that the loan approval was received." Okay, so similarly here, you're not required to deliver the entire report, just a summary of the report. So a buyer is entitled to a summary of the milestone inspection report at seller's expense and before closing, and submitted to. It's the report that basically the condominium association has. Then you have the structural integrity reserve study. This entitles buyer to receive from seller prior to the sale of the property a copy of the most recent structural integrity reserve study report, or a statement that the association has not completed the study, because not every association will have it completed, and it doesn't apply to every association either. So be aware of that. So that's the actual rider, how you're going to see it. And then this is sort of a summary that I gave you of each of those things, because I wasn't sure if you would be able to read the red line version of the addendum.
Michael,
Yes.
I believe Richard Schultz has a question for you.
Okay, sure.
Richard, take yourself off mute.
When it says milestone, what are the milestones? What
Right,
defines the actual milestone?
I'm gonna give you a chart that gives you those, but essentially it's if the building is more than 3 miles from the coast, it's every 30 years they have to have this milestone, and then every 10 years thereafter. If you're 3 miles from the coastline or within 3 miles, it's going to be 25 years, and then every 10 years thereafter. And I'm going to give you a chart that you can sort of use as your cheat sheet so that you know exactly when these things are supposed to happen. And by the way, there's a lot of glitches in this bill, which is what we're going to go over. There's a lot of things that still need to be sort of sorted out in the courts. There's a lot of things that already have been discovered that are problems. So it's highly likely that we will see a law this year that fixes those glitches and probably lessens the burden on these associations, because I think we're probably headed for catastrophe here soon if something doesn't change, because it's going to create a huge burden on these associations. So we'll get to that in a minute. I'll make it a little more clear for you here shortly. All right.
Thank you. Thank you very much.
Condo. So you're very welcome. Condo and co-op riders then are, as of March 20th, are going to be updated in all of our form packages. And these riders, again, are being changed because of the new Surfside condo law. Generally, the new condo rider basically does a few things. It entitles the buyer to the milestone inspection report, the structural integrity reserve study, or a statement that it's not yet been completed. That's what the buyer's entitled to, and that's what the seller is required to deliver. Now, again, not all condos are going to be required to provide reports, because the law only applies to certain condos, and also because some associations have not yet obtained the inspection report because they're not due yet, for example. Also, I've been told that a new disclosure form is being created to address these changes, and a new section will be added to the seller's disclosure form for condominiums as well. All right, I'm going to skip that. That's a duplicate slide. Sorry about that. Disclosure law in Florida, the disclosure law is this, and it has been for many, many years. It's because of a case called Johnson versus Davis, a Florida Supreme Court case, which said this, that sellers must disclose latent defects that are not readily discoverable by the buyer and that materially affect the value of the property. So the question is that, to what extent does the seller have to disclose defects in the common areas or in the building when they're selling a condo? Well, again, this has changed. So now we are going to be required to deliver reports that will presumably show the prospective condominium buyer what's going on in the building. And again, keep in mind, under Florida law, you're required to give a complete set of condo docs, which will now include the milestone inspection and the structural report. And by the way, when you see MI, that means milestone inspection. When you see SIRS, SIRS, it means structural integrity reserve study. And again, remember, they can rescind the deal within 3 days from the receipt of a complete set of these things. So you want to get them to the buyer as early as possible, and you want to get them to sign a receipt so we can stop them from being able to cancel the deal as soon as possible. All right, let's talk a little bit about due diligence. I went over this in the last meeting that we had, but I thought it was important to review once again. And so inspection, you obviously want to inspect the individual unit, but now because of Surfside, because of all of these other things that have happened, I think it's also important to inspect the common areas, walk the common areas, look and see if there's rebar sticking out or there's deterioration in the structure. Probably a good idea to do that and have your inspector look at the common areas as well. Review building repair issues, the maintenance status of the building. Have they deferred maintenance for a long time? What are the things that the association is contemplating in the immediate future? Look at the meeting minutes. Very important to look at the meeting minutes. Again, the meeting minutes are going to give you the pulse of what's happening in the association. And it's going to give you a lot of great information that you otherwise would not know about, because a lot of times, especially if it's an absentee owner, like the guy that I represented, who was from Colombia, and they sold this new unit, and they knew nothing about what was going on. They got letters and they probably threw them in the garbage. So you might have a seller like that. So it might not be a bad idea to get your hands on those minutes. You want to review the building financials and reserves. And again, going back one quick second, is the seller is presumed to know what's happening in the minutes. And if it appears in the minutes or in the agenda, meaning a special assessment or major repair, if it appears in it, then the seller is going to be presumed to know, and the seller will have to pay it, as opposed to figuring out what's going on, disclosing it, and shifting the responsibility for the payments of the special assessment after closing to the buyer. Again, financials and reserves, very important to look at. The repair and maintenance expenditures, what are they spending? How much are they spending, and what are they spending it on? Good idea to talk to the board, talk to the management company, and carefully review these new reports. if you can get your hands on the summary of the milestone and of the SIRS report, good idea to take a look at it. You might want to require a special contract clause that requires the delivery of these reports and these documents within X number of days. To put an affirmative obligation on the seller to deliver them. Same thing with the minutes. You might want to include an additional seller representation or warranty that says that the seller is not aware of any structural issues, for example, or they haven't received any notices from the county or the city regarding structural problems, etc. You want to, of course, require a detailed seller's disclosure, and you want to review the developer and builder background. Obviously, if the building that you are buying in was built by the same entity that built Surfside, you might want to move on to another building. Independent inspections, of course, physical inspections of the unit important. Walk the common areas, as I mentioned. Determine what the monthly assessments include, and obviously what special assessments are pending and what those include. And future assessments, of course. The number of tenants that are in the building, collections, delinquencies. Current pending litigation is important. You want to review the screening procedures, of course. That's normal. Look at the restrictions. And again, require that those reports be delivered to you within X number of days after the effective date, because the rider doesn't give a time frame. It just says that the buyer's entitled to it, which it should say seller shall deliver, but it doesn't. So we may want to make it more of an affirmative obligation within a certain time frame rather than just rely on that condo rider. I would also, if I'm a buyer, I'm going to go talk to residents. I'm going to go there on a Saturday and I'm going to go by the pool, and especially if I can find a tenant, because they'll tell you everything. Oh yeah, you don't want to buy here. This building is horrible. They're doing this and they're doing that. So not a bad idea to talk to residents. So one of the things that this condo law has done is that it's also awake. It's been the condo terminations have now become a hot topic again. Very hot button issue. A lot of increased developer interest now.
Mike,
Yes.
before we go
Question?
forward, we have two folks with their hands raised with questions.
Sure. Ask away. Thank you.
Lisa Alvarez, go ahead.
Yes, Mike, usually when somebody's getting a mortgage on the condo, they get a PUD letter and they get the estoppel letter with all the how many are renting and what's in the budget and stuff. How do we as realtors able to get all that information? Do they just give it to us without paying for it, or can we do a estoppel letter to get that?
I mean, good question. I mean, to the extent that the lender will share that information with you, I don't see why they wouldn't. But I would just ask the lender to give you that letter so that you can be aware of those issues. But yes, Fannie Mae and Freddie Mac now have a 5-page letter that they send, a PUD. Condo questionnaire is what they call it. Used to be like a 2-page letter. Now it's 5 pages. And yeah, I mean, if you can get your hands on that letter, that would be great. The other way to do it is to just put an affirmative obligation on the seller to provide that information. Seller shall provide, A, B, and C by no later than 20 days before closing or something of that nature. And that's those would be the 2 ways that you would be able to elicit that information.
Thank you.
You're welcome.
And Myron, you had your hand up. Go ahead and ask the question.
Community with a contract and have a reserve study, 96 pages. So I didn't know if the reserve study that's provided by the company, or is there a Florida, executive summary form that's submitted? What do I share with the prospective buyers?
Right. It's supposed to be a summary, and good question. It's supposed to be a summary. They usually don't deliver the entire report, and the problem is that again, this is such a new law that everybody's sort of still getting their bearings and what they're required to do and not do. So they should have a summary. So I would request from the board, if they have a summary, and if they don't, then you deliver the report, I suppose. Because you're not going to go and summarize the thing yourself, but they should have a summary, because that's what the new rider says, is that the prospective unit owner is entitled to a summary, not really the whole report. But it also doesn't say in the statute that if the summary is not available, you're not allowed to deliver the report. So I would say just deliver the report until further notice.
Crystal, you had a question? Crystal Schwartz? Crystal?
Muted.
Okay, there you go.
Looks like I'm unmuted now. So
Okay.
we've had a lot of special assessments posed since Hurricane Ian. And let's say we're in contract already and the buyer has already gotten all of their HOA disclosures or condo disclosures. How do we tackle that new assessment that comes from the HOA post having all of that done?
Sorry, if you could repeat the question. In other words, you've gone into contract and now there's an assessment that's imposed after. Was that the question?
Correct. Yes. And say the buyer's not happy with it, do they have a ability to get out?
Well, again, it would go back to 3D, because once you go into contract, I mean, special assessments are generally not just, come out of thin air. So what that paragraph 3 C1 says, that if there's anything pending, and they define pending as things that have been discussed in the meeting minutes for the last 12 months. So if 4 months prior to your closing, the meeting minutes show that this special assessment that's being imposed right at closing or before is being imposed, was discussed, and it's, I mean, that's something that I would argue is the responsibility of the seller. So, if when an issue like that arises, the first thing we would need to do is find out, was this a pending, quote unquote, assessment as defined in the condominium rider? And again, what is pending? Pending means that it was discussed, or an item on the agenda discussed in the minutes, or was an item on the agenda in the last 12 months prior to the effective date. So we'd have to answer that question, and that would give us the ammunition that we need, I suppose, to try to negotiate for the payment of that assessment by the seller. Okay, does that answer it, I hope?
And then Monica Steinmuller, you have your hand up.
Yes, hi. From my experience, it is very difficult to get minutes and agendas from the past 12 months. And I don't see it specifically written in the condo rider, or is there a section that we can point to when we don't seem to get that from the listing agent / seller?
Okay, good question. This is not required. Okay, the minutes, delivery of the minutes of the last 12 months by a seller is not required in the contract. So what I'm suggesting is that if you have the buyer, I think it would be good practice to at least ask for them. And if you can't get them, I mean, you might be able to get them from the management company, but the seller is in the best position to be able to get those documents. Under Florida law, a condominium owner has the right to do what would be the equivalent of a request for production in litigation, which means that they can do an official records request and request these things, and they have to be delivered, or they have to be given access to it within a certain number of days. So really the best way to deal with it really is to insert an affirmative obligation on the part of the seller to deliver those minutes, within a certain number of days after closing. Again, when you say they're difficult to get, not for the seller's entitled to them by law.
Right.
From a practical standpoint, you're right. I mean, some sellers, I don't want to, I'm not going to do that. I'm not going to give you minutes, or, I can't get them, or whatever. So, again, some of these things, just are more difficult to sort of implement in practice. But, if possible, it's always good to get those if you're a buyer. Okay.
Thank you. Thank
All right,
you.
we're going to take one more question from Batya, and then we're going to let Michael move on.
Okay, awesome. Thank you. I just figured out how to raise my hand on my phone. So, if the assessment was pending, so like I have a particular situation where the unit owners got a letter stating that there would be an assessment in addition to one they've already received. The seller has agreed to pay. we've already closed on it. What happens now if it's after closing? Is the seller still responsible to pay? Because on the condo writer, he did indicate that he would pay.
Good question. Well, keep in mind that there's the doctrine of merger. The doctrine of merger is a legal concept that says that the contract and the deed merge at closing and the contract is extinguished. So unless the provision that would require the seller to deliver or to, I'm sorry, to pay the assessment indicates that it will survive closing, then you're probably going to have a very hard time collecting that money. So it would be something that you definitely would need to address prior to closing, or you would have to have a special provision in the contract which states that any pending assessments that are finally implemented within certain number of days after closing will be the responsibility of the seller, and this paragraph shall survive closing. Otherwise, it's a difficult thing to deal with.
Okay, and then just real quick, going back, how does the seller initiate the contract? You had said it's this.
The approval process, right? And very simply, the seller can just send an email to the management company and say, hey, I sold my unit. You're going to be getting a call from Joan Smith. She's going to be the buyer. That's it. That's all you really need to do. And then, they would also, the association might request a copy of the contract, and might want to send that as well, so they have the information.
Okay, thank you.
Okay. You're welcome. All right. So back to our condo termination. So, right now there's a 95% threshold to terminate a condominium, meaning that 95% of the unit owners have to agree to that termination. So it's a high threshold. And so they're looking to change the law on this to reduce the threshold, but not just to reduce the threshold, but to make it more of a level playing field. Because, part of the problem is that there's no a law that's sort of like eminent domain. With eminent domain, the government has to give you reasonable market value. There's nothing like that exists with condo termination. So they're talking about changing the law to require developers to give people reasonable market value or something close to it, to make it more palpable for these unit owners who are in these old buildings. So there is a push to change the law to make it a requirement that owners get fair market value, and you have a lot of buildings that are deteriorating very rapidly, especially the ones that are on the coast. That even if the building is completely repaired and they pass all these special assessments, those costs to repair those very old buildings are very likely not going to be recoverable dollar for dollar. So it's probably going to be better for those people to sell and to allow for a developer to come in and use the land at its highest and best use. So it remains to be seen how this all plays out. But and previously they had lowered the termination law to 80%, but now it's back to 95%. So it sort of remains to be seen what happens here. But I suspect that what's going to happen is there will be this trend of people selling condo units to developers, and you're already seeing it to some extent, but I think you're going to see much more of it. Okay. All right, so let's move on now to the Surfside condo law. And what the changes are. As I mentioned, one of the issues with this new law is that it has a lot of glitches. They are discovering a lot of different things that it was passed very quickly, and there's a lot of problems with it. And I'll give you one example. The Cooperative Act statute says refers to common areas as common areas, but the condominium law refers to common areas as common elements. And the Surfside law, which is not part of the condo law and not part of the co-op law, refers to common areas. So, these are specific legal definitions that really need to match, because when there's, lawsuits, litigation ensues, these are the things that lawyers focus on. So, there are some real problems with the law. And, so again, it remains to be seen what happens with in the new glitch bill that they've been looking at. So some of the questions are, will this new condo law increase condo foreclosures? And will it financially ruin older condo buildings? Again, that remains to be seen, but it seems that it's very possible that that could happen. Will the new law create opportunities and encourage additional changes to the condo termination law, as we talked about, where they're going to require unit owners to get fair market value and make it easier for developers to come in and take over these buildings and erect new ones? Will Florida lawmakers amend the new condo law to make it less burdensome to Florida condo associations? I mean, this is one of the big questions, which we think the answer is yes, they're going to, because it's going to create catastrophic problems with the condo market. Will the scarcity of land in Florida and strong demand by developers, save the market? Remains to be seen. Could aging condos be the solution to meeting future housing demand? Maybe some of these, old condos can be repurposed for affordable housing or for workforce housing, etc. There's and by the way, 320,000 people relocated to Florida in 2022. So, and this doesn't seem to be slowing down. So again, we have to meet demand, and one way to meet demand is more buildings, higher buildings, and more housing. The focus of this new law, by the way, is basically the primary purpose of it is preventative maintenance, inspection, and maintaining reserve funds. Those are the three things that this law purports to do, which is again making sure that we have safe buildings overall. And of course, it's well-intended legislation, but it could create a major housing crisis for thousands of people that are unable to pay these large assessments. It remains to be seen how this is all going to play out. And note that the new law does not modify the Condo Act, as I mentioned. Instead, it amends the Florida Building Code. So the title of the law is Mandatory Structural Inspections for Condominium and Cooperative Buildings. That's a typo there. It should say cooperative. Sorry about that. So the legislature, what they were trying to do is limit unit owner autonomy, right? I mean, because these boards were basically kicking the can down the road. They didn't want to, they wanted to protect their wallets as opposed to the building. And so rather than allow owners to make these decisions on these major structural items as to whether or not they should be repaired, the legislature didn't want to leave this to chance, and they instead prohibited the waiving of reserves. New obligations and unrealistic deadlines. It creates these unrealistic deadlines that are probably going to be unattainable, and it saddles these thousands of condo owners with these significant costs to produce these reports. So again, it remains to be seen how this will all play out, but I suspect there's going to be a new patchwork legislation to fix some of the problems and to maybe extend the time frames within which these things need to be done, because again, very unrealistic, most of it. So this new Florida legislation requires the establishment of a statewide inspection program on older buildings. It requires milestone inspections, structural integrity reserve studies, and these apply to only buildings that are greater than 3 stories. And by the way, here's another glitch. When they say greater than 3 stories, it doesn't say, well, what if you have a building that has parking on the first 2 stories and then it has 3 stories above that? Is that a 5-story building, or is that a 3-story building? And do we just worry about the the first 3 stories, or again, it's a mess. So we don't know a lot of things here, and again, it's likely that there'll be patchwork legislation to resolve these glitches. The law requires condo associations and cooperative associations to set aside funds for building upkeep, and it prohibits the waiving of reserves. Now, it does. Most people that have read the law, most lawyers that have analyzed this, and including myself, it appears to apply to all buildings. It appears to, but there are some contradictions in the law, which you could probably argue that it doesn't apply to all buildings. So again, stay tuned. That's something that's likely going to change. And of course, assessments, special assessments are very likely to increase to cover these costs. So let's talk a little bit about what these inspections are. So the milestone inspection is a structural inspection that is conducted for life safety purposes. The requirement only applies to buildings that are 3 stories or higher, and if occupied 30 years or more, or if they're located within 3 miles from the beach, they would need to be occupied 25 years or more for it to apply. The Structural Integrity Reserve Study is a study of the reserve funds required for future major repairs and replacement of common areas that are based on a visual inspection of the common areas. the law says that this inspection can be performed by any person qualified to perform such study. So I suppose, could it be a general contractor? Could it be a guy that does drywall? I don't know. Again, another area it's a gray area. But then it goes on to say the visual inspection portion must be performed by an engineer or architect. This again is a glitch. So again, this is where, the lawyers have a field day, because what does this mean? So again, stay tuned. We'll see. So the law goes into effect in 2025, January 1, 2025. And as I mentioned, it applies to buildings 3 stories or higher, older than 30 years. They have to undergo this milestone inspection by no later than December 31st, 2024, then every 10 years thereafter. And if you're 3 miles from the coastline, you have to undergo it within 25 years. Now, here's another problem that the law has. Coastline. It doesn't define what coastline is. And there's another statute that defines coastline, but if you use that definition, there's buildings that are going to be excluded. So again, another glitch. The law requires this SIRS report, the structural integrity report, every 10 years. The waiver of reserves, as I mentioned, is prohibited, but again, the application is unclear. But you can waive reserve for unimportant items, like, you can waive reserves for the purchase of new patio furniture, for example, or, window cleaning. I don't know. You can reserve for things that don't have anything to do with structure or life safety. All reports have to be distributed to the condo owners, and they have to be maintained for 15 years by the association as an official record of the association. And this is going to affect about 20,000 Florida condominiums. And here is the cheat sheet for the milestone inspections. For anybody that's interested, you can take a picture of that one, or again, I can send you the presentation. So the milestone inspection report is going to be done in 2 phases. Phase 1 is a visual examination of the building. If there are no signs of substantial structural deterioration, phase 2 will likely not be required. So it's like with environmentals and commercial. You got a phase 1 environmental, and then if they find something, you might have to go to a phase 2. So similar concept. If there's substantial structural deterioration, this is defined as distress that negatively affects the structural condition and integrity of the building. The SIRS report, again, has to be created 10 years after the condo's creation. And the initial study must be completed by no later than December 31st, 2024. Another glitch in the law, because it ends up excluding certain condos that were built, within 11 years, for example. Another thing that needs to be fixed. The notice requirement. Local governments are required to provide notice of this inspection requirement at least 180 days beforehand. And then if they don't have to send it, if they don't send you the notice, it doesn't mean that the association doesn't have to do the inspection. So again, another glitch that nobody's real sure about how that's supposed to work. In terms of what the SIRS report is supposed to require, well, here it is. It's roof, load-bearing walls, floor, foundation. Now, floor and foundation, a lot of practitioners have said, well, wait a second, this is a problem, because how do you give an estimate on a foundation or the replacement of a floor? So they're trying to remove these 2 requirements from the SIRS report requirement, because again, very problematic according to a lot of engineers and practitioners that have looked at this. Fireproofing, fire protection systems, plumbing, electrical systems, waterproofing and exterior painting, windows, and any matters that are greater than 10,000 that if they're not fixed would impair one of these other items. Okay. Now, the minimum requirements, they have to inspect common areas. They have to provide an estimate for the remaining useful life and the replacement cost. They also have to provide estimates for deferred maintenance expenses as well. And they're required to provide a recommended annual reserve amount that achieves the desired goal, which is to make sure that they have money there for to replace the major items. There's a very high demand for engineers and contractors right now with this law, because everybody's going to be required to engage the services of a engineer or contractor. If any of you have children that are in college, they may want to go become engineers or architects, because there's going to be a lot of work for the next many years here in Florida. So there's expected to be very high demand for labor to complete these projects by the deadline. And because of the construction supply and labor shortages, likely these repairs and replacements are going to have a high dollar cost. And assessments, again, are very likely to increase statewide. There's an example of a condo in Miami Beach, a 37-story, 189-unit tower in Miami Beach that's facing a $30 million special assessment, which is about $160,000 per unit owner. So again, I mean, you're buying in a building, you need to ask these questions because you don't want to get a big surprise, and you don't want your customer, your buyer, calling you 6 months later saying, hey, why am I dealing with this? How come you didn't tell me, kind of thing. So due diligence is going to be important. And this is, these large assessments are likely going to accelerate the condominium termination trend. Note that there is board member liability. The law imposes personal liability on officers and directors of associations if they fail to comply with the obtaining of these reports. So this should further chill the likelihood that members of the public, laypersons, are going to want to become members of a board. Now, I mean, it's a thankless job to begin with. You don't get paid for it. You get yelled at by all the unit owners, and now you're going to have personal liability for not getting these reports. So that could become a problem. The law also requires the Florida Division of Condos to collect data from all condos that are 3 stories or more. So they're going to have to submit their data, and they're supposed to have some sort of a database that you can access as well. The law requires sellers to provide copies of these reports, whether it's a new condo or a used condo. And note that the law requires that the reports become official records book of the association and maintained for 15 years, as I mentioned. And the report has to be distributed to the membership by mail or email. It has to be posted in the common area, and it's got to be published on the association's website. So if an architect or engineer in doing this report determines that there's no need to have reserves, that there's no structural issues, then there's no need to have reserves for that component. So, stay tuned for the stories about the engineer or architect that was paid a few bucks to look the other way. We'll probably see some of that kind of thing, I would imagine, especially here in Florida. Public record, as I indicated, the reports will be available on the DBPR website, and they're supposed to have a searchable database that you can go into to get the report. So in answer to someone that asked about the report and what if, whether it's a summary, well, you can probably go to this database to access it, although I suspect this database and all the information probably is not readily available yet. I haven't looked at it, so I'm not sure, but stay tuned for that. Measuring the age. How do you measure the age of a building? The 30 years, 25 years, etc. Well, the age is measured from the date of the certificate of occupancy of that building. The inspections, remember, have to be completed by no later than December 31st of the year in which the building reaches 30 years of age, or 25 if it's within 3 miles of the coastline. And that is measured from the building CO. Another thing to consider is, opportunities. These reports are now that they're going to be made public and they're going to be in searchable databases. Well, the laws, that since it's public record, you're going to have a lot of developers and investors who are going to be able to delve into these building reports to determine which buildings have the most problems and which ones are the most potentially likely unit owners to sell. It's also going to be easier to identify potential, off-market targets for listings, for example. So, probably not a bad source of listings. These buildings that have problems, calling people and saying, hey, you might want to sell soon before they impose a special assessment. And of course, on the selling side, you want to make sure that everything is disclosed properly. All right, let's talk about some pending bills. So Senate Bill 154 is the one that's being circulated right now that clarifies that the Surfside condo bill is supposed to better inform buyers of the building's physical and financial condition, and they're fixing some of the glitches. It also requires a seller's disclosure of the reports to match the existing disclosure requirements for the other governing documents. And it also is looking to say that buildings that are 3 miles from the beach to be inspected after 30 years. to extend that time frame. And it allows local officials to extend the inspection deadlines if the association has retained an engineer, because the law right now doesn't take that into account. Like, for example, if we get an engineer that finally comes out and says, yeah, your building needs X, Y, and Z, well, if we can't get an engineer until 6 months later, are we in default? Are we in violation of the law? So this will extend that time period. As long as you've engaged the engineer, you're in compliance, according to what they're trying to do with this new law. And again, like I said, very likely you're going to see more bills like this to fix some of these glitches. There's a couple other bills you should be aware of. Federal bills. There is the Rapid Financing for Critical Condo Repairs Act. This allows FHA to insure condo building rehab loans made by private lenders. It'll also allow associations to finance building repairs over 30 years, which will reduce the need, presumably, for large special assessments on unit owners. Then you have the Securing Access to Finance Exterior Repairs in Condos Act. It's a mouthful. It allows condo owners to finance a building repair assessment over 20 to 30 years. It also allows owners to combine a building repair special assessment with an existing mortgage debt and wrap it into a 30-year mortgage. It will unit owners will also have the option of financing only the building repair in a 20-year second mortgage. So, as you can see, there's some fixes that are anticipating these big problems that are likely to come about because of the changes in this condo law. One last one you should be aware of, which is the Miami-Dade Loan Program. Those of you that are in the Miami-Dade area, this is a new ordinance that basically allows people to qualify under this program to provide assistance to cover the special assessments. It allows owners earning less than the median income of $96,000 for singles, $109,000 for couples to qualify for a zero interest loan of up to $50,000 to pay for special assessments. It has a term of up to 40 years. Now, here's the caveat. There's only $9 million allocated. I mean, if you have a 300 unit building, and everybody gets 30,000, the money's gone. So if you want to participate in this program, I would urge you to run, not walk, because it's going to go quick. Owners with assets of more than 50,000 must put down 10% of the loan amount. Okay. All right. That was, I know it was a lot of information, but again, if you want a copy of the presentation, just let me know. Thank you everybody for attending. I'll be happy to take questions, comments, concerns,
and we
whatever you want to talk about.
We do have a few, Michael.
Okay, let's do it.
One of the questions was to clarify, is it 3 stories or higher, or is it greater than 3 stories? In other words,
yeah, the way the statute reads is 3 stories or more, I believe, is what it says. And again, this is the problem with the law, is that there's a lot of definitions and things that they sort of threw together that are problematic, and that's one of them. Again, it doesn't make a distinction on when, where does these stories start. It also excludes, it says single family, 2 single family, 3 single family, and then it has some weird language about how, but if the first 3 stories are non-habitable, so again, in answer to your question, I mean, right now it's unclear. There really isn't a definitive answer other than, 3 stories or more. If it's 3 stories or more, it applies. So if you have a parking garage on the bottom and two floors of residential condos above, it would seem that would apply. Although I suspect that in the rewrite of the law or the glitch law, they're going to address that issue. So I'm sorry, I don't have a definitive answer, but it's because again, it's unclear in the statute.
Understood. Ron, you had your hand up and then you took it down. Was your question answered, or did you have something else you wanted to ask? And then in the meantime, Batya has a question, and so does Susan. So Batya, we'll start with you.
Okay, so I was just wondering, yes, if you can share the slides or whatever information through an email to the group, that would be awesome.
Sure. Yep.
Okay, thank you. Thank you.
No problem. No problem.
Ron, I see you up there. Did you have a question?
My question was answered. It was clarifying whether it's 3 stories and above or just above 3 stories. Thank you.
Okay, perfect. And then Susan, you had a question.
Yes, thank you. If the condominium development just went through a 40-year inspection. Will they still have to have the milestone inspection report and the structural integrity reserve report?
Question. And again, that's also unclear, but I think that because of the specific definition of what a milestone is and what a structural integrity reserve study is, I don't think so. I think that they are going to have to do these things again, even if they've had that report, unless they can show that that 40-year recertification is substantially compliant with what the new statute says. But good question, and I don't have a specific answer for that either. Other
So
than
should I
think it's different.
should I reach out to the association then? Because I know they're redoing the roof and they got like a $10,000 assessment for that and generator. Or
Yeah, I
oops,
mean, I would reach out to the association to see what they, what reports they have available at this point. And again, I mean, because they still have until, there's a deadline within which to do the new reports. It's likely that the 40-year recertification that they do have, if they have it in their possession, is going to be sufficient to meet the requirement. Because again, it's not due yet. So a
right.
lot of them
Okay.
aren't going to have the information anyway.
Okay. All right. Very good. Thank you.
No problem.
Monica Steinmuller, I think you had a question here in the Q&A. Do you want to go ahead and just ask? And Myron, you also had your hand up for a question. Do you want to go ahead?
Yes, as it relates to the milestone inspection and where we are in the process, obviously most not being completed as yet. So as a measure, would we just like to see that they've hired a contractor and we're in the progress or in the process of having that study addressed?
Right. So if you notice what we went over in the beginning on the condo rider and the new language on the condo rider, it says that you either have to deliver the report or provide a statement that the report's not yet available or hasn't been completed. If you have the situation where it's maybe in process or maybe they've already engaged the architects, you'll just have to provide a statement that the report is not available. However, the engineer and architect have been engaged. This is the name of the company, and they plan on doing it by, within however long they've told the association. Hopefully that answers it.
Hopefully. All right. So the other question that's in the Q&A, do you think that these new laws are going to be, and it's put in quotations here, as flexible in time compliance as it is now with that 40 and 50-year recertifications? Sometimes those things drag it on.
Good. Again, good question. And this is one of the things that the legislature is reviewing and addressing now. I mean, a lot of the professionals in the industry, people that are involved in condos, management companies, attorneys, engineers, they are giving their input. And in terms of these deadlines, I think that yes, I think that they're going to have to be more flexible. They're going to, but right now they're not. And that's the important point, is that this law was just sort of thrust upon everybody, and it's like, okay, you got to have this done by this date, but the practicality dictates that it's not going to happen because there aren't enough engineers and architects to go around. There just isn't enough time to do all of these reports for all of these aging condos in Florida. So it's highly likely that the legislature will go back to the drawing board and rework this law now that they have input from people in the industry and condo owners, etc. So it's likely that it will be extended and it will be made more flexible. To what extent, I have no idea. That's what we're waiting on.
All right. And then John Adams, you had your hand up. Did you have a question? Yes, no, maybe?
My question was the 25 or 30 year, if the condo is under 3 stories, say it's only 2, do they have to do 25 and 30 year?
No, the reports only apply to condos that are greater than 3 stories, and then the waiving of the reserves would apply to the 2-story condo. Well, presumably, because that's another one of those areas that I've spoken to a bunch of lawyers on this, and everybody sort of has a different opinion on it. But so it's unclear. But the consensus does seem to be that condos that are 3 stories or less, don't have to abide by the abide by the reserve waiving of reserves prohibition, and then everything that's 3 stories or higher is when your reports come into play. But like I said earlier, again, 3 stories. What is 3 stories? Does it include parking garages? What if it's a mixed use building and part of it's commercial and part of it's residential, and the residential doesn't start until the 6th floor? I mean, so there's still a lot of things in this law that need to be clarified. But you know, in answer to your question, the reports apply to buildings that are 3 stories or higher.
Thank you.
Whatever that means.
And just to clarify as well, so the milestone inspection and the structural integrity report apply to condominium buildings 3 stories or higher, but
Right.
that sprinkler retrofit that you were talking about
That's
is
different, yeah.
6 floors or higher.
Right. Well, it's actually says 75 feet. So that one goes in feet and not stories, which might be the better way to really do this, because again, if there's a parking garage or something, but 75 feet is approximately 6 stories. And buildings that are 6 stories or higher will have to comply with this Florida Fire Prevention Code requirement, which requires the installation of life safety systems and sprinkler systems. And again, you're talking millions of dollars. So that one, my view is that it's likely to be extended once again until all of these other more important issues, I suppose, of structural integrity are addressed.
All right. Got it. So, just some comments, absolutely great information. Thank you so much.
My pleasure.
Somebody said, I feel like this is the perfect storm, and we as realtors may all be exposing ourselves to litigation since it's also wishy-washy. I can't disagree with that one. A lot of requests for the PowerPoint. So if you don't mind, sending it over,
I'll send it over to you. I'm gonna make a couple of small corrections. I noticed some typos, so I'll do that and I'll email it to you, Melanie.
All right, and I've got everybody's email addresses, hopefully. So I will make sure that goes out to everybody. So with that, I know that we ran over, but this has been a terrific information. So I thank everybody for staying with us. And I had mentioned earlier in the chat that this has been recorded, and we will go ahead and upload it to our Sunbelt Title YouTube page so that you can go back and revisit it. And as soon as I have the information from Michael, I will disperse that out to you as well. Michael, thank you so much. I'm going to let you have the last word.
Well, no, again, be careful out there. As you mentioned, that this could open up, everybody to liability. So I would say, again, disclose. When you're dealing in condos, get as much information as you can get your hands on. And warn your buyers that they need to do some in-depth due diligence if they're looking to buy an older condo. And other than that, I mean, I think there's going to be some good opportunities for investors and for listings, and when things like this occur, and that when you hear about sort of catastrophic talk of a crash in the condo market, it's of course it also may open up a lot of opportunities and improve things. So I would just say that, again, be careful out there, and if anybody has any questions on any of the materials, or you'd like to discuss anything further, feel free to reach out. I'd be happy to talk about it. And have a great weekend, everybody, and it was nice spending the morning with you. Thank you.
Thank you, Michael, and thank you all
Thank you.
that attended.
My pleasure.